Ladies and gentlemen, boys and girls, children of all ages, welcome to Murder Church. What's going on, everybody? Coming through right now. Better late than never.
Let's rock.
Boom. Good morning. What's up, everybody? What is going on? I have made it. I'm only slightly late. Again, an hour late. What's happening? I didn't go to sleep till probably 5:30 in the morning. I could not go to sleep. It was a nightmare. So I had to push it out. Finally got to sleep, and then the alarm went off at 8:30, and I was like, all right, I'm not doing that. Not doing it. Dave, what's up? Sammy, what's up? Pammy, good morning. Ola, good morning. Just a crazy Jen, good morning. Pokemon, good morning. Blessed Sunday, y'all. That's the truth. True Crime Butterfly, what's going on? Brooklyn, what's up? Good to see you. Wildside in the house. Thanks for that share in the Seeking Justice Discord, Wildside. I appreciate that. Anybody that can give this a share on the old X machine, I just now shared it out. I'd really appreciate that. Any other socials or Discords you may be in would be appreciated as well. Semi Sharp, BGOG. I think I got everybody. Bassett Page, good morning. Tina, good morning. Yeah, we got the crew in here. We got the regular Buzz Nation in here. I really appreciate it, guys. Yeah, and already coming through before I even got started here, I've already got a donation this morning through the Cash App. Boom. Kathy coming through here with a $4.20. Appreciate that. And I see a pumpkin in there. You're getting already ready for Halloween. Damn. She put a blood, a church, and a pumpkin. Murder Church, baby. I like it. I also love Halloween. So, Kathy, thank you very much. And right now, we were working on a wheel on Friday night. We were up to, I think, a halfway point. 3. Yes, we have 6 on the wheel. So if we can get 6 more, we'll give a spin a rooski today. And like I was saying on Friday night on Feral Friday, sent out a lot of different stuff this past week. Sent out a bunch of goodies. I'm almost caught up. I don't think I'm fully caught up. And actually, Teresa, if anybody sees Teresa come through here, I need to get Teresa's info. I don't have Teresa's info, so I need that sent to publiclybuzzed@gmail.com. Teresa, if you're watching this after the fact, I'd appreciate it. But yeah, what's going on, everybody? Everybody had a good weekend. I've got some cool stuff planned out for today. After this, we're about to watch 2 hours here. I think this is the video. I think there's one more after this. It's only 18 minutes. We might even crush that one if we have a second here. But after that, we're going into closing arguments finally here. I can't believe it. I can't even believe I'm saying that out loud. But today we got the judge and counsel prepare for closing arguments outside the presence of the jury. This is 2 hours. I don't know what this is going to be. I'm sure this is just going to be bickering and arguing about what's going to be let in, even though we've already been doing that literally for the last 8 hours, I feel like. I don't know. This is the craziest trial ever. But also after that, today at 3 p.m. Eastern, I've got Jack from Never a True Word coming on here. It's going to be a really good freaking show. I've got him analyzing a 1965 Phil Spector interview. It's going to be fucking dope. Anybody that's watched all of the shows that we've done in the past, we've done a bunch now. Always interesting to hear what he thinks. So you got to come back through for that at 3. I got this stream going to be dropping you straight into that stream. And then, of course, tonight at 6, I'll be doing a wrestling stream on the second channel. But other than that, bada bing, bada boom. Kathy, thank you so much for the donation. I love a lurker. Love it lurking, baby. Love it work. I'm going to use that as the bells, Pammy, actually. I'm going to use that as the bells. So, yeah, without further ado, let's jump in here and get her moving, folks. Appreciate everyone again for coming through this morning. Get the sound set up here. Boom, boom.
This court is now in session. You have Larry call for the judge presiding.
All right, we're back on the record. Counsel are present. Okay, what would you like to take up first? Okay, do we have any further matters to do concerning exhibits?
Yes, Judge.
Okay.
I think where we left is Wendy asked us to wait till Monday.
Well, we can tell her I need to have these. We're not going to be here Monday. We're not going to be here Tuesday. We won't be here till we're ready to argue to the jury. So I'd like to get these issues resolved. And
I can resolve the ones that I can from my side.
Okay.
Judge, with regard to I'll start with my evidence and then move to the defense's evidence that you requested. With regard to People's 172, that was the DMV photo of Tawny Tyndall.
Yes.
That has been redacted
Okay.
and supplied to the clerk and to the defense.
Okay?
With regard to Lana's resume, the court asked me to look through the transcript, call through and see if Nick Terzian actually established the foundation for that. I believe he was asked questions about it, but it wasn't published, it wasn't shown, there were objections, the court sustained the objections, I moved on. So we're not going to be asking for that.
What
It's
number?
173.
173?
That's correct.
All right, 173 is not admitted in evidence.
With regard to the rental agreement, Mr. Plord simply asked, and that's People's 185,
Okay.
that we make a courtesy copy for the defense. That's being done.
Okay?
And that takes care of the People's evidence.
Okay?
With regard to the exhibits. With regard to the defense exhibits, I would point the court to the following. R to the 5th.
Okay?
That was that close-up photo of the looking down the barrel of the gun.
Yes.
If the court looks at page 5114, that specific exhibit was used by Mr. Plord with Steve Renteria. We would ask for its admission.
Okay? R5 is admitted.
Thank you. With regard to Y to the 5th,
Okay?
that is a photo of the chair from the back. Mr. Plord said, I don't think we used it. If the court were to refer to page 5136, that photo was used with Steve Renteria. The foundation was laid, and he did use it.
Y5 is admitted.
Thank you. With regard
So,
to
before you go, can I have the page number on R5? You cited the page number, I didn't get it.
5136,
That was Y5, R5?
R5 is 5114,
Thank you.
both under Steve Renteria's testimony. With regard to C to the 6th, that was the face page that showed, the box was checked that showed Mr. Spector had urinated.
Yes.
Okay? This is what I would point the court to. It's page 7702. Question. This is on cross-examination. If you'll bear with me, it's very short.
Okay.
Question. That would indicate if, in fact, Mr. Spector urinated before he gave the sample, that would be consistent with a void of the bladder, correct? Answer. If that is what that means, or I'm not sure if that refers to an actual void itself, or if that refers to a prior void, I'm not sure. Question. Okay. And that's under something that is under not a portion that's called sample, it's under a portion called, quote, recent hygiene information, end quote, correct? Answer. Yes. Mr. Middleburg indicated if that's what that means, that it was under recent hygiene information, if that's what that means, then yes, it would indicate he voided his bladder. And then he goes on to say, I'm not sure if that's what that means. That goes to the weight, not the admissibility. We would seek its admission.
I agree. If anybody argues that, if it's an issue, clearly the testimony is what it is and can be pointed out to the jury. So C6 is admitted.
Thank you. And this one. The last one I believe that we need to cover is Y to the 11th.
Okay.
That was the chart that Dr. Spitz on Sir Rebuttal or Sir Rebuttal, whatever it was, indicated he did the 357 analysis.
Yes.
We objected to it on page 10,564. Dr. Spitz agrees.
Yeah, we don't need Phil here for this. There we go.
We didn't have the transcript. Okay. We read the transcript this morning, and basically Dr. Spitz agreed. I asked the question, so if your math is incorrect, and in fact it's a 357 or a .357, not a .347, that would render the chart inaccurate, and his agreement was, his statement was okay. Which is not the best thing in the world, but certainly he was agreeing that if his math is wrong, the chart's wrong. And my position is, if his math was wrong, he agreed that he was talking about the interior diameter or bore diameter, not the width of the actual projectile. That's a huge difference. And although Mr. Plord said yesterday we're splitting hairs, we are splitting nerve fibers. It's a huge difference between the size of the bullet passing through a very small spinal cord, and they're trying to make the bullet very small and the spinal cord very big, when in fact that's not accurate. I think that chart is misleading, and he admitted that it's misleading. We would ask for it to be not admitted. And that's it for us.
Mr. Rosen.
Your Honor, Ms. Berenger helped me with this. This was not my witness, but as I recall, the only part that he was responding okay to was just that one area that Mr. Jackson cited. The rest of the chart there was no problem with. So as an alternative, what we could do is we could just redact that one part of it and then leave it to argument. But the rest of the chart, I don't think there were any quarrels with or any problems with. It was just that one area.
That may be true, but the chart's a comparison. It's literally comparing numbers, and it's inaccurate.
Well, the way I believe it should be dealt with is I think the exhibit should come in, and you pointed out, I mean, you have the testimony, and that's the bottom line. He used the chart, he relied on the chart. Yes, he admitted there were problems with the chart, and I think the way you deal with it is basically, you know,
Then we'll submit.
deal with the testimony. So Y11 will be admitted.
Okay.
Do we have any other exhibits that we have to deal with? Outstanding issues?
Not from the-
just
I think
wait,
That covers the ones
Josh.
that you asked us to inquire,
Okay.
to look at. We still have yet to get, there were a number of redactions, et cetera, that the court ordered from the defense, and we have yet to see those, so.
Yeah, when you see them, when you come back, you'll let me know if there's any problems or if it's not
We will.
acceptable to you.
We will.
We're working on it. If you need a little
Okay,
bit more
that's
time.
fine.
You'd asked us to find some citation stuff. We're still working on it. In fact, as we are here, people are working on it.
Okay, that's fine. Do we have a, do you have a package of instructions? Have you given a copy to the defense?
I did.
Okay.
One packet. The packet for the judge.
Let me go get my glasses. I don't need the eye strain today, so hold on a second.
I had four. We also have, while we're waiting on everybody to come back, here's my notes. I would offer the court some light reading on the issue that Mr. Brunon brought up yesterday, the use of video imagery during final arguments or final summations.
Okay.
This is the Condella case. It's sort of the lead case that every other case seems to cite on that issue, as we're sort of breaking into new technological ground. That court made certain determinations concerning the use of video imagery that was used during the trial, or that was taken, rather, of testimony during the trial, and it sets the standard and sets the rules. And
Oh, okay.
we can argue it at a different time, but I just wanted you to be armed with the...
Understanding, of course, that a decision of the New Jersey Supreme Court.
It's persuasive, I understand.
Persuasive only.
But because this is such a new area, Judge, I don't know that you wouldn't be the first trial court to address it. in
Passy
California.
Page, thanks for that share.
Although we did talk about.
True Crown
we
Butterfly,
addressed
thanks for that
this
share.
issue
Appreciate it,
briefly,
guys.
With respect to Sarah Kaplan, at one point when we thought that she would not testify.
Morning,
We
Salty.
may have been in chambers, but we were all, Mr. Rosa may recall this, we were all sitting around. and
Brooklyn says, who am I more of a fan of, Ozzy or Hulk Hogan? As a human, Ozzy Osbourne. Ozzy seemed like a really cool person. I liked Ozzy a lot. He did a lot of really cool things. At the end, at that last concert, I think he gave $180 million to the Parkinson's for study research. I like professional wrestling a whole lot, and actually don't hate Hulk Hogan like the world hates Hulk Hogan. I'm of the mind that Hulk Hogan was a huge part of professional wrestling and getting it into pop culture and what it kind of became, and I was born after that had already happened, so I don't even know if I'd enjoy one of my favorite things, which is pro wrestling, without the character Hulk Hogan. But the man who played Hulk Hogan, Terry Bollea, was a little bit of a piece of shit. He fucked over a lot of people in professional wrestling. Being at the top of the heap in pro wrestling, he had a lot of stroke, a lot of leeway. In the 90s, he had complete creative control over his character. He could do whatever he want, and he fucked over a lot of people when he could have helped a lot of people, and I thought that was really dirty. Yeah, I'm not the biggest Hulk Hogan fan. I like Hogan. I don't hate Hogan like a lot of people hate Hogan. Hogan gets a lot of flack for a lot of dumb shit that he did, and I'm not trying to say that was good, but yeah, Ozzy Osbourne, better dude.
I think
Better
the
human.
court assumed that we would read that testimony in, and we said, no, we would play her.
But I'm not one of the people that's
video of her
celebrating Hulk Hogan dying. I think that's gross as fuck.
testimony, and the court seemed to have no problem with that.
Okay,
Well, that would be a very different animal.
I understand. I'm going to give it some thought.
Yeah, Ozzy was awesome, man.
All right, shall we?
Ozzy's hilarious,
Begin.
dude.
Yes, Your Honor.
Yes.
It might be helpful if I stated where I think we are, and,
Okay.
and we've had discussions with the prosecution. I think we have agreement on well over 90% of the charge, and I think that there
There
are...
we go. Sibby met Hogan. Says he's a good tipper. every time I've seen Hogan have interactions with fans, he's always been pretty pleasant and pretty decent. I never met Hogan, but I know enough personal stuff from his real life, just being a massive wrestling fan, to know that he screwed over a lot of people, just in wrestling, just knowing what he actually physically did to human beings, because he could, is pretty shitty.
4 issues to be addressed, given my discussion with Mr. Jackson and Mr.
Yeah, there's a lot of grossness like that going on.
One of them is whether
Mainly because of the
court
N-word thing
should-
that happened, and like, what, when he was sleeping with Bubba the Love Sponge's wife, which was a orchestrated ordeal, but they were recording him, trying to blackmail him for the future, and then in that video, he says the N-word multiple times, talking about his daughter dating a black guy, and of course that went out there. So that's why most people hate him, which is definitely a horrible thing. Like, that's just adds on to the person that is Terry Bollea that kind of sucks, or does suck. But yeah, I try to separate, in anything in life, I try to separate the character and their work, art, however you want to put it, from the person. So I mean, I can respect what Hogan did for wrestling while also not, while also understanding that I think the dude's kind of shitty.
Calcrim 359, dealing with corpus delicti. The prosecution has requested it, and we'll explain our objection to it.
That's where I'm at.
The second,
Had a lot
the next
of
two are the
anybody that's in a position to help people that doesn't, that irritates the fuck out of me in all aspects of life. And Hogan was that person, dude. He could have done so many good and cool things for just other wrestlers, and didn't.
ones that the court was well aware were coming. Whether there's going to be a special instruction based on Calcrim 306 dealing with the loss or delay. The prosecution has proposed 2 specials. We will initially take the position, strong position, that the court should not give any instruction under 306, but alternatively,
I don't really know this guy.
if the
Chuck
court were to give
Mangione.
one, we have a proposal.
all he was a jazz
which I'll
musician,
answer the
though.
court in just a second.
Okay.
The prosecution
And then the kid from
has
the Cosby Show.
proposal on 375, which is the Calcrim instruction on uncharged
Crazy
offense
week for
of
celebrity
conduct
death.
or statement evidence. We have our own drafted instruction on 375, which I'm about to hand to the court. We did ask for a very brief pinpoint instruction that I believe I gave to the court yesterday,
Yes.
called Defense Proposal 1. So that's 4 issues. The 5th one is not really an objection as much as some elucidation. The prosecution has asked for 371, Calcrim 371, dealing with potential fabrication of evidence by the defendant. Based on my discussions and understanding of the record, they are probably entitled to that, but we will merely ask for a specification of what evidence the
Shelley, thanks for that
prosecution is
share.
seeking to have that on, so that the limit of the instruction would be clear. And with that, court's permission, I'll approach with what's called Defense Proposed Instruction 2,
Okay.
which is on the 1101B evidence, and Defense Proposal Rate Calcrim 306, which we don't want the court to give, but it's our fallback position if the court decides to instruct on them.
Thank you.
But as we probably agreed on 25 or 26 other Calcrim instructions, and if the government wants to, if we want to just run through the list, we could.
I'll tell you how I do it, and so it'll
Sure.
probably make life easier. What I do is I take the people's proposal. I will simply call out the title of the Calcrim instruction and ask what your position is on it. If you want to join, because I have to fill out the history box on the top, then I'll indicate it's requested by the defense as well. If you take no position, then it's only requested by the people, and if you oppose it, we'll argue it. So you can, okay? Simple enough, and I sign it as we go along, so let me just... And this is subject, and what I'm going to do before we break, since once we're done with this, I intend to go on vacation for a few days, so I can at least use some of my vacation days. This is becoming regular with me, that I end up giving them up, and we waive them once we give them up. We don't get them back. My wife would occasionally like to see me. Well, maybe not. I'm not. Everybody can check on that. I'm totally sure on that.
I can help you. You can give me your vacation days. I'll take them.
I want a phone number, because even though I'm not going out of town, I'll just be home. I tend to read through the jury instructions and through CalCrim 4 or 5 times, and just to satisfy myself. And if I find something that I think I have a sua sponte duty to include, rather than hit you with it on Wednesday morning, I'll call you so that you can work it into your arguments, basically. Normally, it wouldn't be anything that crucial, but just so that you're aware, or I'll get a number from the DA and call them, and they can call Mr. Rosen, or however you want to do it, you know.
Thank you, Commander.
That's fine. However, we can agree on that, how we want to do it, and that's, you know, so that nobody's caught by surprise. Okay, let me just go through here and make... All right, let's start with 200, duties of judge and jury.
Well, this may be just a matter of housekeeping, but I want to make sure that the record is very clear. There was it was reported, I saw this morning, that Mr. Reardon had been
Saw the same thing.
subbed in as chief counsel, amazingly enough.
I think that was a little bit of perhaps mistaken hyperbole. As I understand it, Mr. Reardon is here to consult and to serve, to aid the defense, and he's now part of the defense team, but solely on the issue of jury instructions. Mr. Rosen is the chief counsel, such as there is one that we rely on. I mean, Mr. Brunon is still part of the team. Is Kenny Bodden is part of the team? Is Mr. Plord still part of the team? And Mr. Rosen, and those are the attorneys. Mr. Reardon, as I understand it, is here to work on jury instructions and to assist the defense. Is that correct?
That's absolutely correct, Your Honor. And
You don't control press statements, I understand.
I do not, Your Honor. It may have been a mistaken reference to a belief that I'm a Native American and chief was a proper noun, but no, I am not chief counsel and will not serve as such.
All right, no problem.
My only concern was, and I think the court has cleared it up, if Mr. Reardon is going to be making the arguments on behalf of Mr. Spector, I don't know if the court needs to take the extra step of having him either associated in as counsel, or if Mr. Rosen is simply going to make the representations on the record. Mr. Reardon is not a counsel of record for Mr. Spector, and the record is going to look funny with someone new speaking it. I just want to make sure everything's...
Are you going to be addressing the court, Mr. Reardon?
Well, I am going to address the court.
For the purpose that we've indicated here to work on jury instructions, Mr. Reardon is, now part of the defense team, and he may address the court. Okay?
Thank you.
Thank you,
All
Judge.
right. CalCrim 200, duties of judge and jury.
We'll join in the
So
request.
she's
for
got to
that.
be in like a court reporter
Let me
Hall of Fame or
indicate, I will
something,
go
bro.
through. I don't
Just
know
for
if the
this
people
trial.
have already, to the degree, a modification to take care of gender
does
issues
it
or anything
say?
like that. Have they been?
What I did, Judge, and this is my normal standard operating procedure, I use a pencil and I go through very lightly. I make the modifications that we suggest. There may even be some writing, but the modifications are very clear underneath, so you can see anything that we've proposed to be redacted, and the defense can see that as well.
At some point, when we reduce this to booklet form, which I would hope to have Wednesday morning, and even if we don't, if there's something happens, we have basically 2 days to do it while the arguments are going on. We have people in your office that can assist us, so that's not going to be.
Morning, Cat Grow.
Okay.
All right.
Cat, I sent you something this week.
In my review,
You should be getting something in the mail.
Certainly, I'll just go ahead and take care of that. Those are
be
not
getting
major
your goodies in the mail.
modifications. All right. It's requested by both sides. It will be given as requested. CalCrim 201, duty not to investigate.
We did a modification on that, Charlie.
Okay, and the modification,
was in
I
the
see. You
last-
put the actual addresses in.
Well, I made reference to the jury visit, too, otherwise it didn't read right.
Let me read this. Hold on a second. That's fine. I don't have any objection. Basically, if they would have any such inclination to go ahead and view the scene, that would specifically tell them, don't do it.
I will join in the request.
Okay, thank you.
Excuse me, I didn't hear Mr. Reardon.
He's joining.
All right, thank you.
Thank you. Okay. CalCrim 202, note-taking.
Is there any need for a special reference to juror number 10?
He's our most avid note taker, which everyone has noted. Our engineer, he takes copious notes.
He's on his 13th notebook, I understand.
Hey, that's up to them. That's what they're told before the trial. It's up to them to whatever works for them. Is the defense joining?
We have no objection to, Your Honor. Something like this may need to be modified depending on the outcome of a ruling on whether videos of the trial are going to be used in the case. But why don't we simply don't object to that.
That's fine. Thank you. $220, reasonable doubt.
Join in the request, Your Honor.
All right, thank you. $222, evidence.
The only thing we would suggest, Your Honor, is that this is the standard instruction. It says, presented in this courtroom or during a jury view. I just changed the A to the, since there was a jury view in this case.
That's fine.
Second line.
Second line, first sentence.
Thank you.
Okay, I'll modify it now so I can get it in there. And you'll join in that?
Yes. Oh, I'm sorry.
Yes.
Okay, both sides are requesting it then. Thank you. Yes.
Therapist, you know, good morning.
$223, direct and circumstantial evidence defined.
We join in the request, Your Honor.
Okay. $224, circumstantial evidence, sufficiency of evidence.
We join in the request, Your Honor.
Okay, thank you.
Just pushes a button, they just spin around.
This is, I'm sure for the members of the press who've never watched this is really cutting edge. I was thinking if anyone, perhaps if we could get together as a group and if anyone can get me Dick Wolf's phone number, we could propose a couple of new Law and Order evidence review and law and evidence jury instructions, which I don't see how they couldn't be a smash. I mean, maybe it's just me.
They'll be lined up around the ball.
Definitely, and perhaps we can work out a profit-sharing agreement among ourselves. Okay, this is the nuts and bolts. This is why they don't show it. 225, circumstantial evidence. It looks like it hasn't really been modified. It's just been mental state.
We don't oppose that, Your Honor.
All right, then it'll be given as requested by the plaintiff as modified. Well, it's not really modified. It's just taking out what's already in there, so it's edited more than modified. Okay. Um, 226 witnesses, and it's been both modified and edited by the people, I guess, based upon their view of the evidence that's presented, and I'll hear from the defense. You want a moment to review that?
I think yes, Your Honor.
All right, go ahead, take time. I'm going to do it at the same time. Yeah, I see.
We're prepared to address it, Your Honor.
All right, I imagine what you might be addressing. Go ahead.
We join in the request for a 226 instruction. The first emendation of any other impermissible bias, that's fine. We don't object to the elimination of that surplusage language. We strongly object to the addition on factor 4
You don't like the initial language of a marital relationship with someone involved in the case after a personal relationship?
That's true, Your Honor. A personal relationship covers the ground as to
Who
all
is this new
witnesses.
dude
That's
that
an
they brought in,
attempt
the
to single
bearded
out a
guy?
specific piece of evidence and emphasize it to the in a greater way than the factors generally, and we'd object to that addition.
People wish to be heard.
Your Honor, just on the point that it does single out a particular fact, but that fact was proven in the court. And that's an unusual fact, and certainly it's not, this does not inappropriately state anything that wasn't borne out by the evidence in the case. So we believe it is appropriate.
I believe you can argue it. I believe it is also covered under the term personal relationship, and you're free to argue it. I'm going to take the language out and give it without that language.
Yes, Your Honor.
All right. Anything else in that instruction?
Turning to page 2, we agree with the deletion of witness's character for truthfulness, that there were no character witnesses here. But the next deletion was the witness promised immunity or leniency in exchange for his or her testimony. That should read, was the witness promised leniency in exchange for his or her testimony. We don't believe there's any evidence that would support a claim of immunity, as that's generally understood in a criminal case, but a jury could find on this evidence that there was leniency in terms of the immigration proceedings for Mr. Souza, and therefore that ought to be a factor that's left in for the jury's consideration.
I agree that something has to be done. There at least has been an issue raised that some immigration consequence was offered to Mr. D'Souza, and therefore that has to be, I think, delineated.
I don't know if it's liens here. I think it was a postponement, and he testified.
We probably could use the language, was the witness promised anything in exchange for his or her testimony, and therefore the parties are free to argue it as appropriate.
All I would suggest, Your Honor, is we say any benefit.
Any benefit is fine.
Yeah.
That, I don't have a problem with that. That's fine. Okay.
We can live with that.
Okay.
The words "any benefit."
Right. Promised any benefit in exchange for his or her testimony.
Who strike immunity or leniency.
Right. Okay. All right. Are you going to join in with that language now?
We will, and we join in the striking of the last emendation if the evidence establishes that a witness's character for truthfulness is not
All right.
discussed.
Thank you. I don't see 251, which, shouldn't that be in there?
Can we take a second to glance?
Union of act and specific intent or mental state?
Well, I think that's contained in the.
Our position
Is it
is that's
contained in-
contained in the homicide
It
instruction.
is.
Maybe. Let me
It
just,
is.
let me see, let me just go through the use notes and see what they say.
Yeah, we looked at that last night.
One thing I find interesting is the use notes certainly do not single that out, which you think they would have caught. I mean, I know how much work went into the preparation of these instructions. Doesn't mean that mistakes weren't made, obviously. We're still in the process of sort of getting appellate opinions on CalCrim, all of which have upheld the instructions so far. I'm going to put a paper clip here. If I think it's needed, I don't think anyone would object. It's just a question of it will be duplicative or not. The court certainly has a sua sponte obligation to.
Well, we think that'd be, we probably do. I mean, if you think it's sua sponte, then that you're going to do that. But I think it becomes confusing, and the mental state is specifically addressed in the instructions.
Okay.
Your Honor, we did, and I left this off my list, I had overlooked this, we did in the list that we supplied to the prosecution request 251.
Okay, I'm going to take a look at it, and if I think it's necessary, which would be, it's a sua sponte duty, then I'll give it. And it's not going to change anyone's argument. It's not going to change any material element of the case or how you proceed with it. I'll just take a look at it.
That's true, and we'll we'll think about it, but remind us when we get to 520, there's a paragraph that we think specifically addresses this.
Okay.
And makes it less confusing, but
All right.
in any event.
See, the There's one thing we do need to, before we go past 250 and 251, I haven't looked at the weapons enhancements, because sometimes those are general intent crimes and everyone overlooks them, that the jury has to be instructed. Let me take a look at the indictment.
It's a 12022.
Okay.
You're looking at Calcrim 252 in conjunction with that?
No, Calcrim. I think you said Cal-JEC. Maybe I misheard you. Yes, I'm looking as to the 12022.5A1 and 12022.53B,
Right.
the specific language. Take a look.
No, it's fucking stupid. I'm good with skipping it. If anybody wants to skip it, we could start the openings. Let's see how long the openings are, just out of interest. I'm gonna let this keep going, but like this has been ridiculous. Like it's like you want to do every video, but I swear these right here are annoying as hell. There's no juice in them. Look at these closings though. Opening. Oh my god, the mouse is dying. First opening is, I think it's like 2 hours, so. Hour 18. We could do the prosecution delivers their closing arguments, part one.
So therefore, the general
Everybody did
intent,
want to switch to
if I
that,
give
but
251, I'll probably have
we'll
to
just
give,
roll
rather
this
than
out.
that, I would have to give 252,
That'll
union of
be
act and intent, general and
Probably
specific
Tuesday,
together, and then
unless
you
I do something
delineate
else.
which
I'm
it
thinking about
applies
maybe
to.
doing some covert stuff.
Well,
So
Your
I don't-
Honor, and this may, we asked for 251, but the court has raised an issue that may affect.
I can't do that on court TV.
This is a situation in which
I'm doing it. I'm doing it. Fuck it. We're starting the closings right now. Hour 18. Let's go. Something interesting.
Court is now in
Jesus.
session. The Honorable Larry Paul Fidler, Judge presiding.
All right, the defendant is present with his counsel, the district attorneys are present, the jurors and alternates are present. Ladies and
called it.
gentlemen, we
I
have come
called
to
it.
that part of the trial where counsel now has an
If anybody coming through later wants to watch that, it is on Court TV. I'll even link it in the description below.
opportunity to present to you their closing arguments. Because the people have the burden of proof, they will open first. The defense will have a chance to respond to that argument, and the people get the final argument. It is that way in all criminal
I'll put that in the
cases.
description. That video we were
I
just
had a
watching.
discussion with counsel. We're not setting any time limits on them. However, it is expected that argument will take about 2 days. So that you
2
know what to
days!
expect. Mr. Jackson will give the people's opening today. Whenever he finishes, Ms. Kenny Bodden will begin for the defense and then finish whenever she's done, and then Mr. Dixon will close for the people. The belief is that we will probably finish sometime tomorrow at the end of the day. If for any reason we don't, we will go over into Friday to finish argument, and then you will be instructed and begin your deliberations on Friday. You will be working, as I have told you before, on Fridays from this point forward.
Boom.
The instructions
We made it to the
themselves
closings!
are for a case that has taken this long to try, will not take that long to read. When we come to the instruction phase of the case, you will have your own package of instructions to follow along with me as I read
I'd
them
never
to
hear
you,
it because I can't pay attention. It's making me want to blow my brains out.
and then to keep in the jury room with
No
you.
pun
to help
intended
your
about the
deliberations.
fucking trial we're
It's
watching.
something that sort of has started in the last few years with judges giving
Jesus
juries
Christ.
individual packets. Usually you have one package to take in the jury room. I'm going to try something different and see how this helps you and whether it works to your advantage. I'll ask you at the close of the case how it helped or didn't help you, as the case may be. I can't see any disadvantage to it, so certainly that will happen. So we're looking at getting the case to you probably on Friday. You'll be able to begin your deliberations on Friday. Some things I do want to remind you of. This has been a long trial, and even though we have daily transcripts, we're well past 60 volumes. It is not unusual during closing argument that the attorneys may innocently misstate some of the evidence as you recall it. It would serve no purpose for any attorney to deliberately try to mislead you, since ultimately you will have the record to rely on, but it does happen, and just keep that in mind. And I've told counsel how to deal with that, and hopefully we'll have a fairly seamless argument. Ultimately, if there are questions as to what the evidence is, first you have your recollection, you have your notes, and of course you have the transcripts. You don't have them in the jury room, but if you have some dispute over the evidence, as you will be
We're
instructed,
there, baby.
then certainly the reporter will be available to read the testimony to you as appropriate. perhaps the most important thing that you need to keep in mind is that this is not...
I want to blow my fucking brains out. I don't want Phil Spector to blow my brains out.
...evidence, what you're about to hear. It is argument, and there is a difference. The evidence was the sworn testimony that you heard on the witness stand, any physical exhibits that have been received into evidence, and the jury view, of course, that you had. Those facts, those things are evidence. This is argument. It's an attempt for the attorneys to persuade you, to tell you what they believe the evidence show and what the instructions will show you, how it ties into the evidence and how you should consider your deliberations. But it is not evidence. You have already received all the evidence in this case. It's argument. That's what it is. It's argument. It's persuasion. So please keep that in mind. I will also tell you that during the arguments, the attorneys may refer to jury instructions. We are still finalizing some of the jury instructions, not very many,
no
but
way
there's a few
that anybody could, honest to God, keep up with all of this. Like, you would just have to compartmentalize the very key points, which to me is all of the ladies that have come through and had very similar situations happen.
Working on, and it's possible that in their presentation the final wording will be different. When I finally give it to you, nobody's trying to fool you, but it's my final summation of the instructions to you that governs. It's what I tell you the law is, that the law is. It's that simple. So if there's ever a dispute, and I doubt there would be, it's what I tell you that controls. So with that in mind, I believe we are ready to proceed. Mr. Jackson, are you ready?
I am ready.
You may proceed.
Oh, shit. Here we go, baby. Alan Jackson, closing arguments.
Good morning. Been a long time since I've talked to you the first time.
Dear God.
As a matter of fact, it's been about 5 months since the first time you guys ever laid eyes on us. When you walked into this courtroom some 5 months ago to pick up those jury questionnaires, everybody remember that? You didn't know any of us. But things have changed. When you walked into this courtroom for the first time 5 months ago, you didn't know me. You didn't know Mr. Dixon. You didn't know the defense team or the judge.
Closings are going to be
matter of fact, you didn't even know each
multiple
other.
episodes, guys.
But things have changed. When you walked into this courtroom 5 months ago, you didn't know the facts of this case. You might have thought you knew some things. You hadn't heard the testimony. You hadn't seen the witnesses or met the witnesses. You hadn't seen the evidence. And most importantly, you didn't know who the real Phil Spector is. You didn't know who he is or what he is, and most importantly, you didn't know what he does. But like I said, indeed, things have changed. So with that in mind, now that you know who Mr. Spector is, now that you know what he is, now that you know what he does, now that you know a little bit about his violent history with women and with guns, I want to take you back with me. Let's move out of the courtroom. Mentally, let's move out of this courtroom under these bright lights and those seats you're sitting in, and let's move to a more relevant location. Let's move out to the parking lot. The parking lot adjacent to the House of Blues, the one you've seen so many photographs of. This parking lot. It's February 3rd, 2003. It's late at night. Actually, it's early in the morning. It's dark out. The lot's beginning to empty. Go with me to that location. Mentally take yourselves with me to that location. The lot's not full. The valets are starting to clean up for the night. And you see over toward the side a big, shiny black Mercedes. And as you look to your left, standing in that parking lot, you see Philip Spector emerge from the House of Blues. He's wearing all black, except for a big white jacket. It's oversized, a little too big for him. Too big on the shoulders, too long, sleeves too baggy. And he steps out of the House of Blues accompanied by a tall, beautiful blonde with blonde ringlets. She's taller than he is. She's wearing an above-the-knee slip dress, a black jacket, and she has a leopard skin purse slung over her right shoulder. He's accompanied by Lana Clarkson. As you stand in that parking lot, think about where you are and what you're seeing. As you stand in the parking lot, you begin to hear them talk, and you can overhear their conversation. You can hear as Phil Spector begins to insist that Lana Clarkson come back to his castle. He tries to coax her back to the location. And you listen as she constantly says, "No, thank you. No, I can't go. I've got to work tomorrow. No, thank you. But I can't join you, Mr. Spector." And you listen as he continues to try to lure her back to his castle, back to the Alhambra castle. "Come back to my castle and see my castle." And then just then, you think you hear in her voice a little crack. She may begin to relent. She may actually accept his offer. You're standing in that parking lot, and you're watching this conversation. Let me ask you a question. If you could say but one thing to Lana Clarkson right then, standing at the back of that Mercedes in that parking lot, just one thing. You can say but one thing to her, one sentence, one phrase, even two little words, even if you had to whisper it. What would you say? Had I asked you that question 5 months ago, when you first walked into this courtroom, you couldn't answer it. You'd shrug. And you'd say, "I don't know what I'd say to her." But now that you know the real Phil Spector, now that you know who he is and what he is and what he does, what would you say? Even if you had to whisper it so he couldn't hear. All of you, all 17 of you are thinking the same thing. You can lean over and you'd whisper, "Don't go." You'd simply say, "Lana, don't go." And the reason everyone in this jury box thought the same thing, maybe the words a little bit different, but the thought was the same. The reason that you would say that is because you know something she didn't know. You know the real Phil Spector. And if you thought to yourself, "I'd tell her not to go," it's because you know in your heart of hearts, after hearing all of this evidence, you know in your heart of hearts, he's responsible for her death. He killed her. Let's take a deep breath. I want to back up for just a second.
Fajitas. It's been a while since we've seen that.
And give you some guideposts. Y'all have spent enough time with me now that you know that I'm tickled by guideposts. I like for folks to know where I'm going. I like folks to know where I'm headed because it's easier as we move through this evidence. And I'm going to be covering a little bit of ground with you. I'll be honest with you. It's not going to take me 15 minutes and I'm going to sit down. It's going to be a little bit longer than that. How long, I don't know. But I'm going to walk with you through the evidence. And one of the pet peeves I have is I don't like to stand up and talk at someone or talk to someone. I want to discuss this evidence and I want to discuss the law with you. And I want to do it together. So I want to let you know where we're going a little bit during the course of our conversation. And that is, first we're going to talk a little bit about the law. That's something that we haven't discussed since the voir dire process. But you remember we talked a little bit about the law. I asked each of you certain questions about whether you could follow certain concepts in the law. Now we've gotten to the point where the judge is actually going to instruct you on the law that applies to this case. So we're going to talk about that. Then I'm going to move into a discussion a little bit and remind you folks about the events that led up to what happened inside the foyer on February 3rd, 2003. We're going to talk a little bit about the defense and what the defense attempted to show, what they attempted to present. And we're going to talk about how they failed in their attempts to present what they promised you in opening statement. We're going to talk a little bit about the true Lana Clarkson and who she really is. And we're going to talk a little bit about the true Phil Spector and who he really is and what he really is. And then we're going to summarize what happened inside the foyer that night, that early morning hour at 5 o'clock. We're going to talk about what Philip Spector did, what he didn't do, and what he said he did. So that's sort of the guideposts, and that gives you a general idea of where we're going to go with our discussion. And as I said, the first thing we need to talk about is the law, and kind of get that out of the way. Why talk about the law now? It's not the sexiest thing in the world, but we have to start on the same page. We have to start on the same playing field, if you will.
So, Micah,
and one nice thing
come in here.
About this case, if there's any nice thing about this case, it's that the law is crystal clear. It's not convoluted. It's not inexplicable. It's not difficult to conceive of or to conceptualize. He is charged with one count.
But that's going to take a while.
With the unlawful killing of a person with conscious disregard for human life. You're going to hear me say that 3, 4, 5, maybe a half a dozen times, maybe a dozen times. It's incredibly important as we begin our discussion that everybody's on the same page with regard to the law. Okay, so first I'm going to take the horse, and then I'm going to kill it, and then I'm going to beat it. Because I want everyone to be with me on the law. It's relatively simple, and lawyers, when we write these things, can figure out how to screw up the simplest concept and make it difficult. Let me say it again. And I'll put it up, and you'll see as I walk through, one of the things that I like to have, for you to have with me, is you're literally going to have my thoughts and notes over my shoulder as we walk through this. Philip Spector is charged with the unlawful killing of a person with conscious disregard for human life. You've probably thought of charges like murder and manslaughter and second-degree murder and first-degree murder and intentional murder and voluntary and involuntary manslaughter. Those are terms that are attached to the underlying law, if you will. And in different jurisdictions, they're different. In this jurisdiction in California, the unlawful killing of a person with conscious disregard for human life happens to be called second-degree murder in this jurisdiction. It might be called different things in different places, but here it's defined as second-degree murder. Now, just change some words. The unlawful killing of Lana Clarkson with conscious disregard for her life. Okay, what does that mean? Here's how the jury instruction is actually going to sound when Judge Fiddler gives it to you. He's going to tell you that in order to prove this crime that we happen to call second-degree murder, we have to prove that the defendant committed an act that caused the death of Lana Clarkson, any act that caused the death of Lana Clarkson, and he did it with malice aforethought. So, of course, everybody knows what malice aforethought is, right? Wrong. That begs the next question, because lawyers are involved in this, and they can convolute anything. What is malice aforethought? Let's talk about it, and we'll break that down. Remember the two elements. Keep them in your mind, though. An act that caused the death and malice aforethought. There are two types of malice aforethought.
Nice.
Here in California. Two types.
Thought about
One
going
is
into
express
it,
malice.
also
The
don't
other is
know.
implied malice. Express malice simply means intent to kill. That's what it means, an intent to kill. If you can prove an intent to kill, that's express malice. And that's a classic example. Let's say there's a barroom fight, and one guy gets the better of the other.
It's gonna be a barroom fight tonight.
Guy in the bar. So the other guy that's down on the ground, and now he's got a split lip and a broken nose, stands up and he says to the other guy that he was fighting, you know what, I've got a gun in my car. I'm going to go outside. I'm going to get that gun, and I'm going to take your life. I'm going to kill you. You're going to wish you hadn't broken this beautiful nose of mine. So he walks out to his car, he grabs his weapon, walks back into the bar, points the weapon at the guy's head, and shoots him. An intent to kill? Absolutely. Absolutely. But that is not what is required under the law to prove
There he
implied
is.
malice. or to prove malice aforethought, because there's a second way to get there, and that's the implied malice, and that's what's appropriate in this case. That's what applies in this case, not the intent to kill. It's implied malice, which is conscious disregard for human life. And here's what you're going to hear me say over and over and over. We do not have to prove an intent to kill, okay? We have to prove that he committed an act and that that act caused the death of Lana Clarkson, and there was implied malice. So let's get to the definition of implied malice. This sounds more complicated than it actually is. Look at how the law breaks it down. The defendant committed an intentional act that was dangerous. He knew it was dangerous, and he did it anyway. The way it reads is an intentional act, the natural consequences of which were dangerous to human life. At the time he committed the act, the defendant knew that it was dangerous, and the defendant deliberately did the act with conscious disregard for human life. Now let me break it down one more time. An act
exactly what happened.
that's dangerous, that you know is dangerous. Okay, you can put those three together and just say, you know you did a dangerous act. The fourth thing is you ignore the danger and you do it anyway. Everybody with me? You commit an act that you know is dangerous and you do it anyway. And if that costs someone their life, here in California, that's defined as second-degree murder. Plain and simple. If that act costs someone their life for any reason, it's second-degree murder. If you know that what you're doing is dangerous, and you do it anyway, and it causes death, that's second-degree murder. So it literally breaks down like this. Pretty simple. I mean, there's lots and lots and lots of words that you'll hear from the judge. This is how it breaks down. If you commit an act that you know is dangerous to human life, and you do it anyway, that's the conscious disregard for human life. It's second-degree murder. There were some stories, horrible stories. I mean, I can't conceive that people would do this, but there were actually stories about guys that were taking boulders and bowling balls and things like that and tossing them up over freeway overpasses. People have read about those stories. You're nodding your head. You've obviously heard about this thing. What kind of person would do this? But that's for another case. That's for another discussion. That having been said, here's what the law says about, and this is a good example to use. Here's what the law says about that conduct. Let's go back and think about the three things that I just said. If you commit an act that you know is dangerous to human life and you do it anyway, second-degree murder, right? Now think about it. Tossing bowling balls off an overpass. Family of four is driving along on the 5. Drives under an overpass, mom, dad in the front seat, little Bobby and little Susie in the back seat, and all of a sudden a bowling ball slams through the front windshield. The car flips 15 times, killing a family of 4. Then the defendant walks into court and says, hey, wait a minute, wait a minute. I can't be guilty of second-degree murder. I can't be guilty of anything. But I didn't know that the bowling ball was actually going to hit a car. I've actually thrown bowling balls off the overpass before, and it didn't hit anybody. No way. The law says no. You don't get a free pass. When you engage in conduct that's so inherently dangerous, and you know it's dangerous, and it costs someone their life, that's second-degree murder. I mean, ask yourself, should the guy tossing the bowling ball over the overpass get a free pass? Just get away with that? Absolutely not. You would all agree. Another example.
Dude, that shit happens all the time. I
Pointing
always see
a
those
loaded
stories.
firearm at the face of another human being.
Which you've heard
Pointing
happen multiple times, over and over and over decades.
Loaded gun at another human being. Ask yourself a couple of questions. Is that dangerous? I should see everybody nodding their head, mentally nodding their head. You're damn right it's dangerous. We have professionals in this courtroom sitting behind that glass right there who carries a gun every day of her life. She's a professional. She's trained. She's the bailiff. You've never seen her gun. You will never see her gun. She would pull that gun for one reason and one reason only. If she believed it was necessary to inflict what kind of force? Deadly force. Not, I think I might hurt you force. Not, you might get shot in the toe force. Police officers and professionals pull their gun if they believe it may be necessary to inflict deadly force, because guns are deadly. It's common sense. Every 10-year-old knows. As a matter of fact, I was at dinner with a good friend of mine, Rick Ocampo. As a matter of fact, Rick may be in the court. A friend of mine from the DA's office, one of my very best friends. And I was with his family, Kathleen and his little 10-year-old girl, Megan. Adorable little girl, doesn't stand that tall. If you ask Megan, that little 10-year-old, if you see a gun, what do? She'll tell you, like a little 10-year-old little robot, she'll tell you two things over and over and over. You don't touch it, and you call an adult. You don't touch it, and you call an adult. Why? Why do we teach our children that? Because guns kill people. That's what they're designed to do. This gun, Mr. Spector's gun, was loaded with a very special ammunition called hollow point ammunition, designed to flatten, get larger, and twist and tear like a claw as it passes through flesh. Guns are dangerous. They're inherently dangerous. You saw a gun expert, Jim Carroll, on the stand. When he examined all of the guns, they all had their cylinders open, away from the frame, and remember the big plastic piece that was threaded through the cylinder? That gun is physically impossible to fire. It can't hurt you unless you throw it at someone in that configuration, all right? It is physically impossible to fire. Did you see how he handled those guns? I mean, with kid gloves. He didn't point it at you. Had he pointed it at the judge, I don't care if it has a strap through it or not, we'd still be sending ham sandwiches to the back because he'd still be in custody. You don't point guns at anything you're not willing to destroy. Rule number one. Pointing a loaded firearm at a human being, is it dangerous? Absolutely. If you do it on purpose, knowing that it's dangerous, and every 10-year-old knows that it's dangerous, that's second-degree murder, no matter how it goes off. Now I'm going to get into, I'm changing gears here. This is my gear shift and this is my guidepost. Now I'm going to talk a little bit about intent or lack thereof. The reason it's called implied malice is because we don't have to have an expression of an intent to kill. It's called implied malice because the expression can be implied by the conduct. All right? If a person knowingly points a loaded firearm at another human being and that gun goes off for any reason, that is second-degree murder. Plain and simple. That is second-degree murder. What I want to stress is the defendant is charged with one count. And that's it. You're looking at it. We've just talked about it. He's charged with one count and one count only. If the gun was in his hand and he was pointing that gun at Lana Clarkson, I don't care how that gun went off. The crime is what? Second-degree murder. Second-degree murder.
We're up. Sit on it.
So if you're in the deliberation room and a juror stands up and says, well, you know what? I'm convinced beyond a reasonable doubt. I know he was pointing a gun at her.
And I believe this was...
I mean, the evidence is obvious. It's clear. He pulled the gun out and he was pointing the gun out and he's threatening her. But you know what? What if the gun went off accidentally? Juror number 3, you would stand up and you'd say, it doesn't matter. It doesn't...
Said that many times. Honestly, it doesn't seem like he wanted to intimidate the women. But either fucking way, him repeatedly putting a gun into a woman's mouth or into their pointing at them, period, any way, shape, or form at their head, and in this situation, into Lana's mouth, and the gun goes off. No matter how that happened, he put her in that situation. Whether she struggled and it went off, and she accidentally even hit it, whatever, he put her in that situation. That's where I've been the whole time.
How the gun went off. It doesn't matter. That's how you'd correct that juror. And it's incumbent upon you all to follow the law. And the law says it doesn't matter. If another juror stands up and says, you know what, I know he pointed the gun at her, he was threatening her with the weapon, the evidence is overwhelming, of course he was threatening her with the weapon, but what if she slapped his hand? Juror number 12, you'd say, it doesn't matter, right? It doesn't matter how the gun went off. She could have slapped his hand, it could have been an accident. Another juror stands up and says, well, what if he had a trimmer? We've heard that his hand, what if he had a trimmer and the gun just went off? Juror number 2, you'd say, it doesn't matter. It doesn't matter. It just doesn't matter how the gun went off. There could have been a strong wind blowing through the door and the gun goes off. It doesn't matter. There could have been an earthquake and the gun goes off. It doesn't matter. He pointed the loaded gun at her face. That is an inherently dangerous act. If the gun goes off in that circumstance for any reason, the crime is second-degree murder. The crime is second-degree murder. That's why I want to make sure that that horse that I've just beaten to death is in all of your minds. It's very clear. I don't want there to be a mistake. I don't want, once you guys go back into the deliberation room, once you folks go back there and start discussing this, I don't want there to be any misinterpretation of the law. Discuss the facts all you want to, talk about the facts, mull the facts over, but the law is clear. If you decide that Philip Spector was pointing that loaded weapon at Lana Clarkson, and keep in mind where it was pointed, it ended up in her mouth. How it got there could have been a couple of different ways. Did he force her to open her mouth and he put the gun in? Was he pressing the gun against her lip and she opened her mouth to scream and the gun fell in? Was she talking and he leans over and the gun ends up inside her mouth? It doesn't matter. It's not like he was pointing the gun at her foot. He was pointing the gun at the most vital organ on the human body, the brain, the face, the head. If that gun goes off for any reason, it's second-degree murder. I told you I was going to beat that horse to death. I want to make sure that we're all very clear about this. And then, of course, there is what's called a gun use enhancement, and this is the easiest thing we'll talk about all day. If you decide that he's guilty of second-degree murder, which the evidence clearly shows, then unlike the bowling ball incident where there was no gun involved, here in California, if there is a gun use during the crime in any way, if the gun was personally used by the defendant, then there will be a question that you'll get on a verdict form from the judge, and it'll say, do you find the defendant guilty of second-degree murder? Yes. And was there a gun involved, or true or not true? You would mark true, because obviously the Colt Cobra is in fact a gun. I talked to you at length during the voir dire process. You'll recall. Take a look at what kind of water I'm drinking, by the way. I can use all the help I can get.
Oh, I didn't know Smart Water was been around that long. Holy shit.
Smart Water. I don't know if it's going to help or not.
He's plugging Smart Water right now. It's crazy.
See, it didn't help. I forgot what I was talking about. Damn it. Direct and circumstantial evidence. We talked about direct and circumstantial evidence a little bit in the voir dire process, and I remember it's my habit and custom to get a promise from all of you. So if you're in this box, I talked to you about it, or Mr. Dixon talked to you about it, we got a promise from you as far as direct and circumstantial evidence. Those old movies drive me nuts. Those old James Cagney movies where the guy walks out, it's black and white, he's wearing a fedora, and he walks out to a cop, and the cop is some flatfoot, and the guy goes in some, New York brogue.
That's the most modern thing that's been in this trial is the Smart Water.
He'll make fun of me for this, but he says
everything
something
else
like,
looks so ancient.
You got nothing on me, cop, it's all circumstantial, right? and I quiver. I think to myself, God, we're sending a horrible message to actual jurors out there. It sounds like there's something wrong with circumstantial evidence, right? I mean, you got nothing on me, it's all circumstantial. That is an incorrect statement of the law. Absolutely 100% incorrect. Direct evidence and circumstantial evidence are entitled to the exact same weight. The exact same weight in a court of law. And I'll give you an example. We talked about it a little bit in the voir dire process. Let me remind you, because it's a cute example, quite frankly, and it'll bring everybody kind of back to where we started from, right back to the beginning. Remember that little boy in the snow that we talked about? Anybody remember that? Nobody? Yeah? Okay, all right, here we go again. The little boy is standing at the back porch. There's this beautiful blanket of snow it's just fallen overnight, and there's a gorgeous blanket of snow, untouched, virgin snow, if you will. And there's a barn about 100 feet away from the back door. And that little boy looks up and says, Mommy, Daddy, whatever, I'd like to go over to the barn. Say, okay, fine. He puts on his galoshes, and he walks over to the barn. And you watch as he makes little tracks in the snow, right? Then the question before the court is, who put the tracks in the snow? And obviously there would be direct evidence, because we'd call Mommy or Daddy or whoever was standing there, and they'd say, I saw him put the tracks in the snow. Okay, so that's one way to find out who put the tracks in the snow, and that's direct evidence. Now change the scenario a little bit, and the little boy says, I want to walk out to the barn.
Yeah, welcome in
Say,
here.
okay, that's fine. You turn around, you turn your back.
This is closing.
Pour a cup of coffee.
Made it to the
Right?
opening,
By the time you get back
the
to the
first
back
part
door,
of the closings.
You see little Bobby standing across at the barn. He turns around and he's stomping his feet, and he turns around to you and he waves. Hi, Mom. Hi, Dad. Whatever. And you look down, and there's one set of tracks heading from the doorstep to the barn door. And that set of tracks is about the size of little Bobby's galoshes, and you look, and they lead right up to where his feet are. Now the question before the court is, who laid the tracks in the snow? Is there anybody in this jury box that would have any problem with that evidence saying, of course little Bobby laid the tracks in the snow? Well, that's circumstantial evidence. There's not a shred of direct evidence as to who put those tracks in the snow. Not a shred. It's completely circumstantial. But as you can see from that very obvious example, circumstantial evidence is just as powerful as direct evidence in any case. And the judge is going to tell you, Judge Fiddler, you don't have to take my word for it. Judge Fiddler is actually going to tell you, direct evidence, circumstantial evidence, you give it the same weight. So if there are deductions you can make from circumstantial evidence, then you make those deductions and you're comfortable with them. And there's no need to discuss, well, I think that's only circumstantial. Oh, no. The answer is, absolutely, it's circumstantial. That's great. Thumbs up. Circumstantial evidence is just as powerful as direct evidence. And that is the law you swore to follow. Here's where we're going to, and that's my discussion of the law. See, that wasn't so bad, was it? Wasn't like pulling teeth. Now I want to remind you of the facts leading up to what happened at 5 o'clock in the morning. You all remember them. You all know them. As a matter of fact, you've all been taking copious notes, some more copious than others. I think there may be a record set, sir. In any event, if I get anything wrong, Judge, I guarantee I will be corrected on the record. I want to remind you, it's been a long time. It's been a long trial. We've gone through about 4 months worth of evidence and 70-odd witnesses. I just want to come back to where we started from and talk about how this trial began and what led up to the events, ultimately, that took Lana Clarkson's life. The events, ultimately, that led Phil Spector to point that gun at her. And when the gun goes off, it takes her life. So let's talk about that. What happened on February 3rd, 2003? Actually, February 2nd, 2003. I should have indicated it was the day before. You all know it was the day before, in the evening hours. This will just remind you of all the locations that we've talked about. Obviously, that's the castle. That's the Alhambra Castle. You've all been to the Alhambra Castle at this point. When I first introduced this stuff to you, it was probably a little bit vague. Now that you've sat through the facts, you know this stuff as well as I do. We start off at the grill, move over to Trader Vic's, go to Dan Tana's, and recall we end up at the House of Blues. And there was a pattern going on. as Philip Spector moved through Los Angeles, moved from the grill
Sheila.
and Trader Vic's
Hey, thanks for that share,
over
Sheila.
to the
Appreciate
House of
that.
Blues, and that pattern included starting off with certain witnesses, starting off with dates. And at each point, if you recall, at each point, Phil Spector began to drink. And you might have thought at the beginning of this trial, why was it important that he drank? So what? So you're
Navy
out at dinner with
Grog's
a
in the
couple people
chat.
and have a couple of cocktails? What's the big deal? That's how it starts.
Phil Spector's drink of choice.
That's how it starts with Philip Spector. That's how the real Phil Spector begins to emerge. You'll recall that, just to bring us back up to speed on what he was drinking that night, you'll recall, according to the evidence, that he had at least 2 drinks at the grill, starting off with Rami Davis. You'll recall once he moved over to Trader Vic's, he had 2 more drinks, but those drinks were special. We even got the recipe.
Navy Grog right there. Amaretto sour, but a Navy Grog is, what is that, 1950 in 2007? So, 2 Navy Grogs is 1950. I guess this is in LA, but holy shit.
For those drinks during the course of this trial, 6 shots of rum in those 2 drinks.
Damn.
He moved over to Dan Tannis. We heard from an employee at Dan Tannis talking about the fact that he had 2 drinks, probably daiquiris. Remember, he described them as, he thought they were gold in color and they looked like daiquiris, but he wasn't the one that served them, so he wasn't sure. But clearly, he had $33 worth of a bar bill. It's consistent with a couple of daiquiris. Kathy Sullivan then came in and said, yeah, in fact, I remember that he had 2 cocktails there. And then, of course, the Bacardi 151 that he was drinking at the House of Blues.
They were drunk
He
as
shot
fuck.
that
He was for sure.
and wanted another. But Sophia Holguin refused to give him another because it was, at that point, I think 1:59 or close to 2 o'clock, real close to 2 o'clock, and she didn't give him another drink. This is the pattern of drinking that Philip Spector engaged in on February 2nd and February 3rd, 2003. What did Rami Davis tell you about Spector's behavior? What did this alcohol begin to do to Spector? How did he begin to react and act as he continued to consume alcohol throughout the evening? Remember that Rami Davis had been dating Phil Spector for the better part of the year. They had met at their high school reunion the early part of the year before. Or maybe it was the springtime of the year before in 2002. They continued to date throughout 2002, and now we're into 2003. And they were social daters. It was a platonic relationship, but they were good friends. They were social daters. And she said something interesting. Up until this weekend, she had not seen him drinking before. Up until this weekend, he hadn't consumed alcohol, at least in her presence. As he began to drink there at the grill, she said that Mr. Spector was not his usual self. Phil wasn't his usual self. What does that mean? Actually, maybe she didn't know the usual Phil. Maybe she didn't know the real Phil Spector. Maybe she had just seen the person that was putting on airs while he was dating this beautiful, elegant woman. But tonight was different. Starting at about 7 o'clock at dinner, he began to drink. She wasn't. And he began to drink at least 2 drinks in her presence. And her comment was she wasn't his usual self and that he was beginning to act totally different. Keep in mind, at this point, it's starting. At this point, it's starting. We're starting to see the real Phil Spector emerge. What did Kathy Sullivan tell you about his conduct during the course of the night? Remember what she said. She joined him at the grill. She wasn't drinking with him at the grill. She was working there, recall? She joined him at the grill, and then they moved off to Dan Tannis. That's when he really started to shift into second and start drinking heavily. He drank those 2 Navy Grogs, 6 shots of alcohol. Then he moved on to Dan Tannis with her. And remember what she said about his mood. Even at Dan Tannis, after Trader Vic's, even at Dan Tannis, he started to get snippy and angry and loud. He looked at those, he sort of mad dogged, I'm using a colloquial phrase, but he sort of mad dogged those patrons out on the sidewalk at Dan Tannis. And she said that his behavior began to snap. Once at the House of Blues, he just snapped at her. Remember what she said. Once they got to the House of Blues, she said, you know what, I've had a long night, I don't feel, she said her words, I don't feel pretty. I'm in my uniform. I don't feel like partying. It's, 1:30 in the morning, going on 2 o'clock, 1:45, something like that. And no, I don't want to drink. I just want water. So Sophia Holguin walks up and says, folks, may I take your order? And what does she say? I'll have water. And he says, have a drink. And she begins to see his mood change. The real Phil Spector is beginning to emerge. No, Phil, I just want water. I'm tired, I just want water. Just sit down and have a fucking drink, was his comment. His comment was rude enough and out of character and out of sorts enough that it actually made Sophia Holguin uncomfortable. Kathy Sullivan said after he barked at her, it sort of embarrassed her. And she wasn't into it. She just wanted to go home. But she refused to have the drink. Phil Spector wanted control. The real Phil Spector was beginning to emerge. He's out on a date. Think about it. He's out on a date. Not even a date, a platonic friendship with Kathy Sullivan. But he wanted to drink. I'm Phil Spector, and I want to drink, and I want you to drink with me. Well, no, thanks, but I just want water. Just sit down and have a fucking drink. That's the real Phil Spector. That's the control he exerts on others. That's the person who will not take no for an answer. So he barks at her. When it's not working with Kathy Sullivan and she decides she wants to leave, Phil Spector starts hitting on Sophia Holguin. Well, you want to have a drink with me? No, sir, I can't. I'm working. Well, I'll tell you what time do you get off? You want to come back to the house with me? You want to have a drink back at the castle? I'll show you my castle. And Sophia Holguin says what? She says, you know what? I've got a boyfriend. I'm sorry. I can't. Lovely to meet you. Not going to happen. Phil Spector was on the move. He was on the prowl. Phil Spector wanted what he wanted, and he wanted it right then. After the Bacardi 151 was consumed, he wanted to continue to drink more. This was the mood that Spector was in.
That's how it goes.
This was the frame of mind that he was in.
Even if you're
and
already
this
lit.
is how it starts.
We'll keep her
Every
going.
time he's confronted
keep
with
the
this
party
situation,
going.
this is
That
how
was me
it
Friday.
starts.
I
This
probably
is
drank
his
2 more beers
motivator.
after I got off Friday, which
This
was
is how
not
he's
smart.
motivated. And even Sophia Holguin, as I said, noticed that he was loud and boisterous. And the word she used, angry. Adriana D'Souza gave you some insight. He spent more consistent time with Phil Spector than anybody else through the evening because he began the driving and he ended the driving. What did he tell you about how Philip Spector was acting at the House of Blues? He said that once they, Philip Spector and Lana Clarkson, emerged from the House of Blues, Spector continued to insist that Lana Clarkson join him, continued to insist that she join him back at the castle. But she kept saying no. She kept resisting. He continued to insist more. Well, I'll tell you what, then let me take you back to where? You know what, I'll just get you in the car. Let me take you to your car. I'll take you to your parking lot. No, Mr. Spector, no, I appreciate it. I've got to work tomorrow. My car's in the parking lot. No, it's late. I've had a long day. I've worked a full shift. No, thank you, but no. Spector wouldn't take no for an answer. He wouldn't take no for an answer. Come on back to the castle. Come back to my castle. I've got a castle in Alhambra. I want to show you my castle. Let's go back for a drink. Finally, she says, you know what? No, I don't want to go back to the castle, but I'll take your ride to the car. Once back at the car, once back at the parking garage, then, and only then, does she relent and say, okay, you know what? All right, one drink. He continued to insist, and she said, okay, I'll go back for a drink. Now, why would Lana Clarkson agree to go back to Phil Spector's house at 2 o'clock in the morning or 2:20 in the morning, something like that? A man that she barely knew. Think about what Euphrates Lalandra has told you about Phil Spector. She didn't even know who Phil Spector was. As a matter of fact, she thought he was a woman. He had kind of wild, crazy hair. He was wearing a woman's jacket. It was oversized. He was diminutive in size. Hello, Mrs. Spector. Remember that? Kind of a little bit of levity.
I don't know if I'd like a Navy grog.
Sophia, I'm sorry.
The Navy grog, Poke put it into the Discord, into the Murder Church portion here. She says, to make a Navy grog, place in your shaker 3/4 ounce each fresh lime juice white grapefruit juice, a club soda, which I don't think I like club soda, 1 ounce each gold Demerara rum, dark Jamaican rum, and white Cuban or Puerto Rican rum. Whoa, so many rums. And 1 ounce honey mix. That is a fancy drink.
Euphrates Lalandra has immediately corrected her. No, that's Phil Spector. Okay, fine. Who's Phil Spector? Well, you know what? I'll tell you what. Don't worry about who Phil Spector is, but you treat him like Dan Aykroyd. You treat him like he owns the place. You treat him like gold, was the comment to Lana Clarkson. So now
Gold,
Lana
Jerry,
is standing
gold!
in the parking lot with a guy that she has just been told, and she hadn't had the job all that long, what, 4 or 6 weeks, something like that, at the House of Blues? And she's taken the job for one reason, because she thinks, at least for one of the reasons, at least because she thinks there might be some good connections here. Remember the conversation she had with Nick Terzian? And she said, Mr. Terzian, she said Nick, and Mr. Terzian related to us, hey, you know what, you think I should take this job? It's kind of, it's a, and he said, where is it? Oh, it's at the House of Blues. Well, what, are you going to be like bartending or what? Oh, no, they want me at security. They want me to be the VIP room hostess. And Terzian said, at the foundation room? And she said, yeah. And he goes, take it. Are you crazy? It's exactly what you want. It's exactly what you need. That's how you network in this town. You're coming back off a long injury. That's how you network, of course. Take it. So now she's confronted, standing out in a parking lot with this man that she's just been told has the power and the moxie, if you will, of Dan Aykroyd. Treat him like gold. And she's thinking, you know what? Just maybe, this is one of those connections I should probably make. I should probably keep this guy happy. I don't want to piss him off. I'll go back and I'll have a drink. It'll be fine. No big deal. That's her motivation. And finally, as you know, they get back to the castle. She accepts the ride. Adriana D'Souza drives them together back to the castle, and he drops both Lana and Phil Spector
been a trip.
at the front
Over a
steps.
year.
And you all saw those front steps. There's, 84 of them or 88 of them, something like that, going up to the front of the house.
Been a
And
ride.
what does Phil Spector
Episode
notice?
94?
Sorry. What does Adriana
Crazy,
D'Souza
man.
notice about Phil
It's
Spector's
insane.
demeanor at that point? Remember, he said he smelled the odor of alcohol. Well, it wasn't Lana. Lana hadn't been drinking. Lana just got off work. He smelled the odor of alcohol. His speech was a little bit slurred. And as he moved his way up the front steps to the castle, his gait was a little bit unsteady. And Lana Clarkson looked like she was kind of helping him almost as his gait was unsteady. So we know the facts are very clear. I don't think anybody has any question about Phil Spector's state of inebriation. Was he so blitzed out of his mind he couldn't walk or talk? No, of course not. We're not suggesting that. But there is significant evidence that he was under the influence, that he had been drinking. He was feeling no pain, as they say. So they end up inside the house. Adriana D'Souza takes the car up the back way. You guys went up the back way. You know how that there's 2 routes. And he goes up to the motor court and parks this Mercedes right about there. He sits in the Mercedes. It's about an hour and a half, he said. He said they got back to the castle somewhere after they dropped Lana Clarkson's car off. And remember, that's an important point. She didn't just leave her car in the parking garage. She insisted that they move her car. Why would she want to move her car to the street? If the parking garage closes at, say, 3 o'clock in the morning, why move your car? If you're planning on going over to Phil Spector's house and drinking and partying and playing all night and spending the night there, just leave your car in the parking garage. It's safe there. Pick it up the next morning when it opens back up at 8 o'clock or whatever time it opens. No. Gives you rich insight into what Lana Clarkson was thinking when she accepted that ride. And that insight is, I want my car. I'm going to go back to the castle for a drink or two, but I'm leaving. I'm leaving. Ultimately, I'm leaving when I want to leave, and I'm going to make sure I have my car available when I do it. So they get back to the location. Adriana D'Souza, after dropping the car off and doing the switcheroo and all that kind of stuff, they end up back at the location around 3:30. Said about an hour and a half passed or so. An hour and a half passed or so. And as he's sitting in the car, in the Mercedes, the door is closed, and he hears pop. What was that? What was that? He gets out of the car and he walks around. Your Honor, may I briefly? He gets out of the car and he walks around the front of the car. Walks around the fountain and back. Now, he estimated to you that took, I asked him on direct examination, do you know how long that took? He said, when looking at my watch, he said, I'd estimate about a minute. Well, folks, you guys were out at the location. You saw how far that fountain is. At a gingerly pace, at a relaxed pace, you could probably make it around in 20 seconds, 25 seconds or so, back to the car. He estimated about a minute.
It's been
but
a
you
long
were
one.
actually out there. Let your
Gotta
view
see her
of the
through,
evidence
though.
be your guide as to how long it took. What was it, 20 seconds, something like that. And he ends up back in the car. He doesn't see any broken branches. He looked at the front of the car. There was nothing that fell on it. He didn't know what he heard at that time. It came out of nowhere. And keep in mind, this is a military man. This is an officer in the Brazilian military for 9 years. He's heard gunshots more times than any of us combined. But that was so out of place, he didn't place it. He gets back in the car. No sooner had he shut the door, he said about another minute passed or so once he got back in the car. So we're talking about literally seconds. Was it over a minute? Was it 60 seconds, 80 seconds, something like that? I don't know. Literally, we're talking about seconds before the back door opened and Philip Spector emerged. And what did Adriano D'Souza tell you? He said, Phil Spector, seconds after the gunshot, literally had the smoking gun in his hand, in his right hand, across his waist. He literally had Lana Clarkson's blood on his hand. He looked Adriano D'Souza right in the face. They were standing 4 to 6 feet apart. You've actually seen where that location is. You've seen how far it is. You've seen what you can see. You've heard what you can hear. And Phil Spector looks at him and says, I think I killed somebody. He told Adriano D'Souza what he had just heard. He unequivocally told Adriano D'Souza, before he had time to think about it, before he had time to come up with something, he told Adriano D'Souza exactly what happened with that pop inside the house. And what were his words? I think I killed somebody. What did Adriano D'Souza do? What was his initial reaction? He grabbed his cell phone and he hit the first speed dial on the cell phone. What was the second thing he did? Everybody knows. The second thing he did when he didn't get a hold of Michelle Blaine is what anybody would do. What anybody would do in an emergency.
What are you reporting?
Hi, my name is Adriano. I'm a Hugh Spector driver. I think my boss killed somebody. Please, can you send me a...
Do you think your boss killed somebody?
Yes, sir. Yeah. Because I'm driving way outside and I don't know what it is.
Okay, where are you at?
It's 1700 Grandview Drive, please.
1700 Grandview?
Yes.
And why do you believe he may have killed somebody?
Because you have a lady on the floor and he has a gun in his hand.
Okay, stay on the line. Do not hang up.
What a crazy 911 call.
You're in Glendale?
No, I'm on the Alhambra. It's 1700 Grandview Drive.
Did you hear him shoot or anything?
Yeah, I heard like a noise, and then he opened the door, and I think I killed her. And then I'm outside the castle.
Okay, stay on the line. Do not hang up.
What's happening at this juncture is the CHP, which receives 911 calls. We all heard about that. They receive 911 calls off of cell phones. They then transfer the call to the appropriate agency. The call was transferred to Alhambra, and the call continued.
Alhambra CHP. We got a transfer from an address of 1700 Grandview Drive, reporting that he thinks his boss just shot and killed the woman.
Okay, and then,
He heard the shot and he said there's a woman lying on the floor and his boss told him he thinks he killed her.
okay, and he's inside the house?
It's inside of business.
Business?
Yeah. I'll bring him online. He's calling from cell phone 310-488-5548.
Okay, hello?
He's on.
Sir?
Yeah.
Okay, what happened?
Oh my God, again.
Oh, okay, your boss shot someone?
Yeah, I think so.
Oh, you think you heard a shot?
Yeah, I heard the shot outside. Then I'm outside the castle because I don't know what.
Is this a residence?
No, it's a residence.
Okay. Have you seen your boss?
Yeah. He had a gun in his hand.
Oh, and where's the man now?
Yeah, come here.
Sir, where's the man? The man with the gun, where is he?
Oh, inside the castle because I'm outside. I'm afraid to go inside again.
But you saw him with the gun?
He's afraid to go
I saw him
inside.
with the gun.
Who did he shoot?
I don't know. I don't know the lady.
Okay, so stay on the line, okay?
Okay.
This is someone.
Fast.
Okay, hold on, okay? Sir, you,
Yeah.
you said that's your boss. Okay.
Yeah.
Where's he?
I'm his driver.
Oh, you're his driver?
Yeah, I'm his driver.
What do you drive? In a taxi or what?
Sorry?
I'm sorry, what are you driving?
I'm driving Mercedes.
What are you driving him to?
Oh my God.
Looking up with me to follow us.
Okay.
Okay, so...
Possible shots fired,
You're
700
the
South
transport
Grandview
service?
Drive at the Castle.
No, I'm a private driver.
He heard one shot
Adriano.
and stated he saw his boss
Okay,
holding
and
his
the boss's name?
possibly shot at a
Yes,
woman
sir.
inside the Castle, 1700 South Grandview.
Shield
Tell
Spector.
us further.
Seal?
Spector.
Seal inspector?
Yeah.
That's his name?
Yes.
S-E-A-L?
P-H-I-L. Spector.
C-H-I-L. Is he Asian or white or...
Sorry?
Is he male white or Asian? Is he an Asian person, a Hispanic person, or a white person?
No, it's a white person.
And his name is Phil, C-H-I-L?
Yeah,
Oh,
P-H-I-L.
Phil.
Phil, yeah.
Phil Spector? Okay.
Yeah. Sorry?
You see or hear anything else?
I'm outside the castle. I'm not inside anymore. I'm afraid to go inside.
I don't want you to, okay? And what's your name?
Oh, I saw the car.
Copy.
You're not the car?
Yeah, the police car is coming.
Okay, sir. Well, what's your name?
Adriano.
Oh, okay, I'm sorry you gave me that.
You're saying a seal has committed murder?
Called the SOUDA.
Okay, and your phone number is 310-488-5548?
Yes.
Okay, has a unit made contact with you?
Oh,
You see you saw the police unit?
no, it's coming now.
Okay. So, hold on, please.
04.
The last call was the broken refrigerator. Can I drop this phone off?
Okay, hold on. What color is your Mercedes?
It's black.
Make sure that the officer made contact with you first before I...
Okay.
Okay?
He's inside the castle, sir. Inside up.
Okay, so go and talk to him, okay?
At the time that Adriana D'Souza was speaking with the 911 operators, both of them, the CHP operator and the Alhambra operator, and by the way, the reason that she asks questions over and over and over is they are trained. to make sure they keep you on the line, even if they have to ask the same inane question 15 times. Your name is? John. Okay, and what did you say your name was? John. All right, fine. Have you made contact with the police? No. And I'm sorry, sir, your name was what? John. They are trained to make sure that the person on the other line stays on the other end of the line, stays on the line. So it may sound kind of odd. Another thing to take note of, who was misinterpreting who, or whom, I should say, during that call? Adriana D'Souza had no problem understanding anything either of the 911 operators were saying. None. They might have had a little bit of a problem understanding him because he was on a cell phone and it wasn't the clearest connection, but he had no problem understanding their English. He had no problem interpreting what they were saying or hearing what they were saying. What he had no way of knowing at that time is exactly what had happened to Lana Clarkson. He indicated during the course of his testimony on the witness stand that he had looked around Mr. Spector. He said he looked beside him after he asked, "What happened, sir?" Remember, the way it happened was Phil Spector said, "I think I killed somebody." Adriana D'Souza frowned and said, "What happened, sir?" And Philip Spector's answer was a shrug with, as Mr. D'Souza said, a stupid face. A shrug and a stupid face. Adriana D'Souza looked past him and saw Lana Clarkson with blood on her face, but that's all he knew. There's a woman with blood on her face. He had no idea that Philip Spector had put a bullet into the back of her head, shot her through the mouth. And Adriana D'Souza never got to see what Philip Spector did up close. He never saw these photographs. He never saw her up close. By the time he was informed by Philip Spector what he had done, what Spector had done, it was too late. Lana Clarkson was already dead. And think about, if you will, the difference in reaction. Adriana D'Souza, sitting outside in a Mercedes, hears a pop. Mr. Spector says, "I think I killed somebody." He sees a woman with a little bit of blood on her face. And he immediately leaps into action. He immediately runs from the scene, from the back door where Spector was holding that gun. And what does he immediately start doing? He starts calling for help. He calls Michelle. You can hear the panic. You can literally, it's palpable. You can hear the panic in his throat as he calls Michelle Blaine and says, oh my God, I think Mr. Phil killed a lady." And then he immediately calls the police. He immediately contacts the police. What was Phil Spector doing during this same time? Think about it. Think about some of the things that he was doing. Just put that in the back of your mind as we talk about this. Where'd the gun end up? Where'd his jacket end up? What about that diaper? What about her face? What was Phil Spector doing while Adriana D'Souza was calling for help to help this woman? What was Spector doing? Ladies and gentlemen, in any case, any criminal case, the hallmark of a criminal case is that it can be one-sided insofar as the evidence is concerned. What do I mean by that?
I'd be interested in, you could probably do it by just going through every single one of these lives and adding up the time frame on them, but be interesting to see exactly how many hours I've spent on this trial.
I mean, the defense, all these folks on this side of the table have no burden whatsoever. They don't have to present a defense if they wish not to. If they so choose, they don't have to stand up. They don't have to say a word if they so choose. They have no burden. They have no burden of proof whatsoever in a criminal case in California. As a matter of fact, in a criminal case in all of America, they have no burden of proof whatsoever. The entire burden rests with the prosecution. I want to make sure that everybody's aware of that. And we accept that responsibility. Mr. Dixon, myself, on behalf of the office, on behalf of the people of the state of California, we embrace that responsibility. That's how our system of justice works, and it is without question the best system of justice on the planet. They can sit there like a bump on a log. They don't have to cross-examine any witness. They don't have to present a witness. They don't have to make an argument. They literally have nothing to do if they don't want to. But, and you knew there was a but coming, didn't you? But, if they choose to put on a defense, if they choose to make arguments, if they choose to call witnesses, they bear the same obligation, not a burden of proof. They bear the same responsibility and the same obligation to present evidence that is truthful, to present evidence that is honest, to present evidence that is trustworthy. That's their obligation. And if they don't meet that obligation, if they present evidence that is not trustworthy, that is not truthful, that is not honest, if you can't trust the character and quality of the evidence that's presented by the defense, you have an obligation, a legal obligation, to ignore it. In this particular case, they did present a defense. And it can best be described as what I would call a checkbook defense. What do I mean by that? A checkbook defense. That means if you hire enough lawyers who hire enough experts who are paid enough money, you can get them to say just about anything. You pay someone enough money, you can get them to wear a tutu into court. If you hire enough folks and throw enough cash at them, you can get them to say just about anything. And second, if you find a witness that is somehow indebted to you or indebted to someone close to you, either financially or otherwise, you can get them to say just about anything. Pumpkin pie. You can get them to say just about anything. Mr. Spector has spent a long time impressing folks with money. An $18 bar tab and a $470 tip. A $30 bar tab and a $500 tip. I think I did, your memories, and this is what Judge Fiddler was talking about, your memories of the actual evidence, and the actual evidence is what controls. I'm trying to think. I think I added up at one time the number of tips that he left. Just on February 2nd and 3rd, I think it was $1,700. I may be wrong, it's somewhere close to that. But I think it was around $1,700. And probably spent $150 on services. You throw enough money at a problem, and Mr. Spector thinks he can solve the problem. That's what I mean by a checkbook defense. You heard from a lot of folks in this case. You heard from a lot of experts. And we're going to talk about those experts.
Hey, Teresa, perfect timing. I just need to get your information to send you some goodies, all your winnings. If you could send me an email at publiclybuzzed@gmail.com, publiclybuzzed@gmail.com, I'll get you set up.
A little bit of detail at least. But keep in mind, and this is a defining theme throughout my talk with you as I talk about the defense. And you know what? As I talk about the prosecution evidence too, because I embrace the opportunity for you to scrutinize both sides of the evidence. I'm not hiding from that. I want you to scrutinize both sides. I want you to scrutinize the evidence that myself and Mr. Dixon presented on behalf of the people of the state of California. Scrutinize the hell out of it. That's what you're here for. I'll bet you won't hear the same thing from the defense. I bet they don't want you to look as closely at their evidence because it won't stand up to your scrutiny. you have to constantly ask yourself, and you will hear me say this over and over and over, and I apologize about the mantra, but I need to know that you're thinking about this when you're thinking about the evidence. Can I trust this evidence? Can I trust what's being presented? If you have a witness who says A and another witness who says B, there is not a stalemate just because two people on opposite sides of the case say opposite things. That does not lead to a stalemate. Everybody understands that, right? You have to test the quality of the testimony that you're getting. You have to look at the quality and the character of the testimony that you're receiving. And that's what I want to talk about insofar as the defense is concerned. That's what I mean by a checkbook defense. You have to constantly ask yourself, was the presentation by the defense really trying to get after the truth, which is what we're here for? That's what the Great Seal of the state of California, bookended by the flags, stands for. We are here to seek the truth, not to just throw things out at you and try to confuse the evidence. We are here to seek the truth, and both sides should be engaged in that endeavor. But you have to decide if both sides really are or were. Was the evidence trustworthy? And I'm not going to go through in great detail the next points that I'm going to make, but I just want to put something in the back of your mind. Just think about a couple of these things that were presented on behalf of the defense. Daniel Stark, good a place to start as any. Think about Daniel Stark. First of all, what was that all about? If she was having a drink, I mean, we ended up litigating whether or not she was having a drink at a Christmas Eve party a year before. Anybody heard the phrase collateral issue? It couldn't be more collateral. This was a completely collateral issue, but I wasn't going to let it hang out there. Daniel Stark walks in, not in uniform, short sleeves, open collar, waltzes in and says, oh yeah, I remember, I only had 13 months on at the time, but I remember 6 years ago, off the top of my head, I haven't looked at any notes, no reports, nothing. I've done thousands upon thousands of calls since then, but I remember this woman and she was drunk. What? Did anybody think to yourself, huh? Pardon? And then we find out that there's actually an EMS report out there, and it's written down, not under the influence. Then we find out that there's a base hospital form, and it's written down, not under the influence, no ETOH. And then we find out that there's a recording of the actual call, and the nurse says, what, is she under the influence? And on tape, Bruce Liverpool says, no, she's not under the influence. The defense presented you with none of that. They found the answer they wanted, and that's all you got. And if we hadn't stood up in cross-examination, started exploring a little bit about this, you wouldn't have gotten to the truth. And finally, we introduced you to the actual person who was attending her. And what did we find out about who was attending her? This wasn't new to them, to the defense. Bruce Liverpool was known to the defense. He was contacted by the defense, and he didn't give them the answer they wanted, so they went to the other guy, Daniel Stark. Remember his phrase? I'll never forget this. When he's on the stand, he said, oh yeah, Tawny Tindall approached me, and she said, hey, can you give us some information about Lana being under the influence? And remember what his phrase was? You may not recall this. It stood out in my mind, and I wrote it down. He said, you know what? I think I can help you. Not, oh yes, I remember that occasion. Not, oh yes, I can give you the truth. Not, yes, I remember that specific incident. It was, this is the Spector case? Oh yeah, this is televised? I think I can help you. Can you trust their presentation of the evidence? Or are they trying to manipulate? Tawny Tindall. There's two things we know for sure about Tawny Tindall. She didn't testify in this case, but we found out two things for sure. She doesn't record any of her conversations. Kind of a basic point for an investigator, wouldn't you think? one of the things, and Mr. Rosen is an outstanding cross-examiner. And one thing, and I've got to take a little bit of credit, Mr. Dixon and I have to take a tiny bit of credit for Mr. Rosen being so accomplished at cross-examination. He had transcripts to cross-examine every one of our witnesses with. Because our investigators record their conversations. Why? Because we got nothing to hide. It is what it is. I mean, if you sit down with someone and you don't have a tape recorder, I understand that. I dig that. It's fine. You're out and you meet a witness, you don't happen to have one on you, okay, fine. But if you're going to a location in order to interview a witness, tape record them. What are you hiding from? We're after the truth, right? Tawny Tyndall didn't record a single conversation. So we'll never know. And more importantly, you will never know what her conversations with Pumpkin Pie and Jennifer Hayes and those folks really consisted of. You'll never know what her conversation with Daniel Stark really consisted of. And the other thing we know about Tawny
Closing arguments, life artist.
She lied about her identity.
First video.
She literally talked to Bruce Liverpool. You remember that? Bruce Liverpool said, oh yeah, I was contacted by this real nice lady. She had long blonde hair and her lipstick was a little too red. Her name was something funny. To him, and I'm not being pejorative, I mean something odd, I should say. Something extraordinary. Tawny Tyndall, oh yeah, that was it, Tawny Tyndall. And he was shown a photograph and he identified Tawny Tyndall as the person who contacted him. And remember, she's the face of the defense to the public. The defense team has a face to the public that is their investigative agency, if you will. And that is, in fact, Tawny Tyndall in this case. And what does she do? She gets information from Bruce Liverpool she doesn't like because he said, no, you know what, look, based on the information that you're giving me, I don't think she was under the influence. I can't say that. Okay, thank you very much. And by the way, who are you with? Who are you with? Oh, I'm with a civil firm. Don't worry about it. I'm with a civil firm. My name's Tawny. I'll talk to you later. This is a civil case. Literally lied to his face about who she was. Why? Why would she lie? Why would she lie about her identity? Because she thinks that maybe the next phone, if she says, I'm on the Spector case, the next phone call that firefighter might make is to the DA's office. Hey, I was just contacted by the defense, and they asked me X, Y, and Z. Lie about your identity? Jackson and Dixon, they'll never know. And we can have Daniel
thanks,
Stark
Teresa.
take
Just
the
got
stand
that.
and tell the jurors basically anything we want them to.
Get you going
and they'll
tomorrow.
never know. Oops. Think about the photographs. Sorry, Judge.
I was just about to ask. Be a good timing to break?
Yes, thank you.
Okay, no problem.
Made it through the first video
Keep in mind
of the state's closing arguments.
Thank you.
Holy shit,
When
we're
the
getting
jury
there,
is gone,
folks.
I need to address some people in the audience. I suggest that you hold on for a minute. Thank you. Go ahead and have it.
Oh shit, address some people in the audience. Uh-oh. Maybe the laughter that broke out?
The jurors and the alternates have left. This is for the people in the audience. Apparently some of you didn't get your exercise routine in last night or didn't get enough sleep. Some of you are rather obviously stretching and yawning and doing things like that. If you'd like to remain in the courtroom, keep that up because you're going to be gone. We have people waiting to get in. You will act in a courtroom appropriately, and gesturing and stretching so obviously that it becomes ridiculous. If you do it again, you're gone. That's real simple. It distracts the jurors from listening to argument. Number two, do not have conversations among yourselves. Do not shake heads. Anything else, if you hear argument you don't like. That's all part of the way it's done, and if I see anybody doing that, you will be removed from the courtroom. Thank you very much. We're in recess.
Judge that hard. All right, we're going to be done today on this, but at 3 o'clock today, I've got a banger coming at you. So the next part 2 of this, again, prosecution still delivering closing arguments, will be an hour. We'll do that probably Tuesday, honestly. But what's about to happen at 3 today, I got Jack from Never a True Word coming on. He's going to be analyzing a Phil Spector 1965 interview, and I'm very excited about this. It's going to be interesting. I think it's a little... It's kind of, there's some telltale stuff in here that I think will plague Phil Spector later in life, especially with women. This is him pretty young. It's him on a talk show, and there's a female guest, a movie star, on here. Richard Pryor's up there too. A couple of different celebrities, but the way that they interact is very interesting. So you're going to want to come through. This stream is going to take you right into that stream again in less than 3 hours, folks. Come back through here, hang out, or having a day with Phil, and we're almost done with this shit. Holy crap. Holy crap. And I'll put it there in the chat. I think the next trial I'm going to do is going to be Charlie Adelson's trial as we approach Donna Adelson's trial. And this is something that I know a little bit about. I don't know everything about the Adelson's trial, but I did watch with Jay, and I know a lot. I know Jay was deep into it, but I think that would be an interesting to go into just for the Donna aspect that's coming up, and I think it's an interesting trial. So I think that is going to be what we go into next, but we still have a while. We're not done here. We have many hours left to go still, so... But everyone, thank you all so much for coming in here today. I freaking appreciate it. Please come back through at 3. We're going to have a good one. You're not going to miss it. Have a great Sunday. I'm going to get some lunch. Let's go. Boom.